Meg Bauer is here on behalf of Pine Valley Place. Excuse me, on behalf of Mr. Stroop. Jessica Larson is here on behalf of the plaintiff. Is your client here?
Your Honor, my understanding is my client was dressed and prepared to be here and waiting for the bus that the ACT team coordinated for him, and our belief is that the bus did not arrive to pick him up. That is okay. I don't need his presence to defend this matter.
All right. This was a very, very difficult case. Mr. Stroop is full of bed bugs, bad bed bugs, and he stripped down to like one chair and a carpet or something. And so a conditional order of dismissal was entered. Plaintiff asked to execute it, contending that the defendant had violated the agreement. Ms. Bauer from Legal Aid has filed what she's entitled a specific and verified objections to entry of that termination of tenancy. Ms. Bauer, you wish to speak to that?
I do. Thank you, Your Honor. The parties, as you've outlined, the parties settled this matter almost 8 months ago. They settled this matter by conditional dismissal agreement. That agreement is a contract that should be interpreted under Michigan law as a contract. So the primary issue before you, Your Honor, is did Mr. Stroop violate that contract? If he did, then does the plaintiff come itself with clean hands, or has the plaintiff also violated the contract? And the answer to those questions is no, Kevin did not violate the contract. And no, the plaintiff doesn't come here with clean hands. No, the plaintiff did not do everything that it agreed to do under the contract. So the plaintiff has not established the conditions for reinstating the case. Right now, the case is dismissed. The defense is asking that the case stay dismissed because by the terms of the contract, Kevin agreed that he would prepare his unit as set forth in this order. This order that we entered had treatment instructions set forth for heat treatment. There are 3 pages that were integrated to the order, into the order at plaintiff's insistence, pages 6, 7, and 8 of that order. And by plaintiff's own affidavit, Kevin complied with those treatment requirements. Kevin has not broken this agreement. The question before the court is not, does Kevin still have bed bugs? What is the condition of Kevin's unit? The only question before this court is, did Kevin break this agreement? Has plaintiff established the conditions for reinstating the case? That's a requirement to reopen a case under a conditional dismissal. And the answer to those questions is no. Kevin didn't break this agreement. Kevin did what he agreed to do. And I've got Ms. Farley here from the ACT team prepared to testify to the fact that she helped prepare him for that treatment. She was present on the day of the treatment to ensure that that treatment unfolded and to ensure that Kevin was prepared for that treatment because he was. Oh, as I said, this is a contract. It follows contract law. So it's not a question of equity. It's not a question of sympathy. It is simply a matter of did Kevin breach this contract? And he didn't. Plaintiff doesn't like the contract that it agreed to. That doesn't render the contract void or avoidable. Plaintiff has the burden of proof to establish that Kevin failed to comply with the terms of the settlement agreement and to establish that the conditions for reinstating the case have been met. The conditions for reinstating the case were set forth in paragraphs 7 and 8 of the settlement agreement. Paragraph 7 of the settlement agreement reads in full, or in part, I'm sorry, defendant shall have the right to remain in possession unless he fails to prepare his unit as set forth in this order. The parties agree that if Mr. Stroop fails to prepare his unit as set forth in this order, the plaintiff may reinstate the case. By plaintiff's own, I'm going to say affidavit, but I don't actually know who wrote out the bullet point statements or the basis behind them. If Ms. Larson is testifying to those statements, then we're going to have an issue because the attorney of record can't be a witness of fact. But by their own admission, the heat treatment occurred as scheduled. On March 21st, Kevin's room unit was prepared for the heat treatment, and that heat treatment was undertaken. The paragraph 8 of the contract goes on to say that the parties agree that the plaintiff may not reinstate this case unless plaintiff's request for reinstatement demonstrates that plaintiff has fully complied with its commitments in this stipulated order. Now, those facts are a little bit more complicated. We don't actually need to look at that because Kevin prepared his unit as set forth in this order. At no point in time in any of the unsubstantiated or unverified affidavit allegations did they indicate that Kevin was not prepared under the terms of pages 6, 7, or 8 of the agreement. If there's an issue and if they want to evict Mr. Stroop, that is their prerogative, not in this case. They do not get to reopen a case that was settled by contract 8 months ago, or 1 day shy of 8 months ago, and they have an immediate, unnoticed, non-due process eviction of him, and no opportunity for him to raise any defenses to the new allegations that they're bringing. One of the things that the plaintiff committed to doing in that settlement agreement was notifying Mr. Stroop's supportive care team through Pivotal Act. And even based on the dates set forth in this alleged affidavit or affidavit of alleged default, every date that they notified, that the plaintiff notified the ACT team of additional treatment, not the heat treatment, but additional treatment in Kevin's unit was prepared and treatment was administered. Only once they stopped notifying the ACT team did there arise any kind of issue with his unit. But again, those treatments are independent and separate from the all-inclusive heat, a thermal remediation package that was stipulated to in the settlement order. So the only question before the court is, has plaintiff established that Kevin defaulted on this agreement? And they cannot do that. Kevin did what he agreed to do, whether they like what they agreed to or not. Kevin did what he agreed to do, and therefore this case must remain dismissed. Thank you, Judge.
All right. I'm looking for the actual document which triggers the request for termination, and I can't find it. I've got your objections and your specific and verified objections, but I can't find the pleading that triggers this. Ms. Larson, what's your position?
Your Honor.
Say that again.
My office, we filed an affidavit requesting the reinstatement, Your Honor, and attached to that was an incredibly detailed summary of what has occurred. And
I believe that, but I can't find it.
Is there an email address that I can send that to, Your Honor?
I have one copy of it here, Judge. It does have my notes on it. I am happy to share it with you.
Yes, I'm sure it's somewhere because it triggered this, but I can't find it.
I know we
The
filed
electronic
it. We wouldn't
file.
be here if I hadn't filed it.
Yeah, I believe you. I think the problem is either I can't, it's labeled under something I can't determine what it is, or it isn't in here, but I can't find it. And I was looking for it on Friday, or on Thursday. Wasn't here Friday. Yes, would you please email it to 3bcivil@stjosephcountymi.gov. And Elaine, as soon as you get that, will you bring it to me?
Could you say that one
What
more
we're
time? Your Honor?
discussing here, 3bcivil@stjosephcountymi.gov. And Elaine, if it's in there somewhere, I can't find it. I don't know what it's labeled as. And I clicked on everything that was in there. Maybe it's just because I'm frazzled at the end of a long day. So what we're discussing is like a 9-hour trial. And it got put in here for 15 minutes or 45 minutes. And this, I've spent, I don't know, 20 hours on this case so far. We got to the conditional order of dismissal. Plaintiff moved to set that aside, and I'm sure you did. The fact that I can't find it, it's more reflection on me than you. But Mr. Stroop has been a problem tenant for a long time. He suffers from mental illness. He's under the supervision of the ACT team and has been for some time. They help him a lot. But he's got cleanliness issues, and I don't know that they ever did get the bed bugs out of that apartment. There's always the issue of did he bring the bed bugs to the apartment, or did the apartment bring them to him? But at this point, plaintiff is interested, and I would sure be in a better position if I had that pleading. So Elaine, as soon as you get it, will you bring it to me? I gotta split this, or
I've emailed that over, Your Honor.
All right, thank you, Elaine. Would you print that and bring it to me? All right, what's your position?
It's got 53 pages of attachments to it, Your Honor, that gives a detailed history of what's going on in this case.
All right, well, obviously I should have that, and I don't. So that's on me. I should have really figured out on Thursday that I didn't have it. But go ahead.
So our position, Your Honor, is that Mr. Stroop unfortunately defaulted in the obligations that he was set forth to do. That he did not properly have the unit in a state that could be eradicated from bugs. I do have available, she's not on Zoom, but she's on standby with just a quick text, a representative of Pronto Pest Management who can talk about the dozens of times that they have been in the unit since February, trying desperately to get this under control. They were not able to eradicate with the heat treatment that was performed. And they have been requesting of Mr. Stroop additional steps that he has to take, vacuuming the unit regularly, cleaning the clothing and other items, not only that are in the unit, but that he's wearing in a specific manner to avoid reintegrating and reinfesting of bed bugs that may be on his person or on backpacks or duffel bags or things that are
and frankly I'm glad he's not here, because we had issues here at the courthouse. We had to treat it after he would come here. And then there's an issue
that their bed bugs are going into other units, and my client is now incurring costs to have the other units treated. And they have managed to eradicate in every other unit but Mr. Stroop's. And so I want to be incredibly sensitive because I understand the struggles that Mr. Stroop has. But this
Where is
is not an
this?
issue that is going away, Your Honor. This has been an ongoing worsening issue over and over and over again. Pronto is in there regularly. And Mr. Stroop is not doing what he needs to do on his end in order to get this taken care of.
All right,
I also
thank
want
you.
to note, Your Honor, that counsel pointed out claim deficiencies in my pleading. I believe that the affidavit that we submitted meets the requirements, but in response, Your Honor, to our request to reinstate, It's stated right in the order, this is paragraph 11, that if defendant objects to entry of the order, his objections must be verified, i.e. notarized. And counsel is the one that signed that document, Your Honor. As Ms. Bauer just pointed out to the court, she cannot be a fact witness. She is the only one that has signed the objections, what she calls a verified statement. Counsel cannot verify those statements. And therefore, we feel that the objections on its face did not meet the terms of the agreement that was reached and of this order. So not only that, Your Honor, but the bed bug issue has it's risen to the level that the government officials are now involved. The compliance services are involved, and they have red tagged the apartment. So this is to the point, Your Honor, that, you know, if something's got to be done, Mr. Stroop this is not a cleanly environment for him to live in. In fact, it's been determined that he should not be living there at the moment, that he is not authorized to occupy that unit because it's been red tagged. So we are well past.
Well, when you say red tagged, has the zoning official condemned that apartment?
They have, Your Honor.
As of when?
I believe on or about October 2nd. So as of just it's after we've moved to reinstate.
Your Honor, the defense objects to any consideration of these additional facts, this hearsay evidence that's been submitted.
Well, whether it's hearsay or not, the zoning people are gonna come throw them out on the street, irregardless of what we're doing here.
With all due respect, Your Honor, that's between him and the township, not between him and the landlord, unless the landlord itself has received a citation. I would like to address the
Stop. We're gonna have to have a hearing on this. We got, A says, yes, he is a menace to the apartment complex. He is so debilitated that he can't maintain his apartment in a safe manner, to the extent apparently the township's condemned it. There was an agreement whereby the case was conditionally dismissed. Everybody wants to hold everybody else to the absolute jot and tittle of it. And if that's true, we don't have a notarized verified objection. So Mr. Stroop isn't in compliance with it.
judge, it is notarized.
By counsel. Counsel is the one that
No.
signed that, Your Honor. She cannot verify her own pleadings.
Your
No,
Honor,
it's notified, it's notarized by Sarah Ritzenholtz,
yeah.
Prestonholtz.
Right. But she's
October
notarizing Ms. Bauer's signature, Your Honor.
And I have not made any statements of fact that would be admissible or need to be admissible.
All right,
But you can't verify your own pleading as the attorney of record. That's for the client. to
They're
do.
actually, I'm sorry, Judge.
all right, I guess we'll have to argue about that further. I've got lots of other people waiting for their matter to be heard. Defendant contends plaintiff did not comply with the terms of the conditional dismissal. Ms. Larson, I wasn't crazy. Your pleadings were not in the file. The clerk couldn't find them either in electronic copy or paper copy. So I'm not sure where they went, but I didn't have them, so I wasn't crazy. They weren't there. But I did realize it on Thursday, and I was gone Friday, and then I didn't have time to deal with it this morning. The issue is we're gonna have to block out 5 days and have a hearing on this, maybe 2 weeks. Let's see what we can figure out here. It's hard to find a large block of time. Are the parties available Wednesday afternoon, November 19th?
I anticipate being in a hunting blind on the 19th.
You and Judge Pattison. Boy. Wednesday, December 3rd, that's a long time to go if the property's been condemned. Are the parties available Wednesday? That's way longer than I'd like to go, but it's the next time I have a half a day.
I have a
Are
hearing
you
that
available?
morning, Your Honor, but if I'd be able to be here via Zoom, I could do the afternoon.
The defense objects to any evidentiary testimony by Zoom.
I,
All right, then I'll set it for November 19th and somebody else can come in and represent the defendant. I'm not gonna continue this exponentially. It was set for today. We didn't have our ducks in a row, so we didn't have the pleadings. But it's complicated. It involves conflicting testimony, absolute nitpick adherence to the agreement. It might actually be simpler to start over again with the termination of tenancy rather than to enforce this conditional order of dismissal. But
Indeed, Your Honor, that's the defense's position.
I understand the defense's position will be anything that gets Mr. Stroop more time, Your Honor.
yes,
I understand that, you know, counsel could have done a professional courtesy by allowing me at least to appear via Zoom. I'm not sure why this case needs to be so contentious, Your Honor. That's certainly not from plaintiff's side what our
I
goal
did not
is.
object to counsel appearing by Zoom. I objected to testimony by Zoom.
yeah, that's a different thing.
I mean, if we can stick with November 19th, Your Honor, and then frankly, I may
It
just sit down
can't.
if
No one
everybody wants
else
to
is
quit.
from legal aid is gonna want to touch this with a 10-foot pole. Ms. Bauer's got all the experience with it. Life is hard. Things aren't always easy and don't elegantly fall into place. November's difficult because of deer season for our court and the holidays. I don't hunt, but I'm here when others are gone. And I have used full days. We lose some days, so I've blocked the entire Fridays that are not first Friday of the month for landlord tenant. So all day the 12th, all day the 19th of December, all day the 5th, our landlord tenant slots are crammed. I'm gonna have this in a different context. If there is a condemnation and the defendant is still there, the township's gonna ask me to enforce the condemnation order. Also the judge that does that.
Yeah, that may frankly be a reality, Your Honor. We're waiting on word back from the township where that's at in the process, if they intend to go forward with that or not.
Is the ACT team aware that they condemned the apartment?
We are aware that it's been deemed uninhabitable and Kevin has been instructed in the 2 areas of the apartment that need to be cleaned for him to return to the apartment. It is his toilet and his fridge only,
Okay,
which we are ready to assist him in cleaning that so he can return.
okay.
The correspondence that I have from the township indicates that the bed bugs need to be gone for him to move back in. So,
All right. Well, there's no perfect answer to this. I'm gonna continue this to December the 3rd. Plaintiff's counsel may appear by Zoom. All witnesses shall be live in person.
At 1 o'clock, Your Honor?
1:15. All witnesses shall be live. During COVID, we took testimony remotely. Since that time, all sworn testimony's been live and in person with a right to confront.
No, and I should have clarified my request earlier was if I could be there in person, I would have had my witnesses present and available either way, Your Honor. So I appreciate the court's accommodation on that.
All right, we're gonna continue this to December 3rd at 1:15. I'll have an opportunity to further review the affidavit, which I didn't have. That I was reading the objections without reading what they were objecting to. So that was when I was looking for it on Thursday and couldn't find it. All right, that's the best we can do here. We're going to continue this matter until the 3rd of December. Ultimately, well, you could do belt and suspenders. You could file a new termination of tenancy action based on new facts. If you don't want to wait till the ruling in this case, if defendant prevails, then you have to start. But if you're terminating his tenancy because the health department has condemned the apartment and there's still an ongoing bed bug problem, that doesn't have to do with the absolute adherence to the dismissal agreement. It has to do with the state of the apartment. So that's an option you may consider. And I don't know. The problem is there's nowhere for Mr. Stroop to go. His rent is either zero or very low. And the reason for being evicted from the last unit doesn't make anybody else really want to take him on as a tenant. He's a high need client. And so they're fighting hard to keep him in this placement. We'll have the fight joined on December 3rd at 1:15. Thank you.
Thank you, Your Honor. Thank you, Attorney Larson.
Thank you.
The title of this case is Ish or Ash, depending on how you say it. Investments versus Jody Sparks. This is filed as a demand for non-payment of rent. What's the current alleged arrearage?
Oh, she's knocked the balance down pretty substantially. As of October, it would have been $4,016. She's got it down to where it's just $994 plus.
Through October?
Yeah, through the end of October, but she got $176.32 worth of costs. Now, you know, there's gonna be another $950 coming up in November, but she's knocked out I'd say over $3,000 worth of back rent.
Well, very good. The total is $1,170.32. Ms. Sparks, apparently you've paid quite a bit toward the arrearage and you're to be commended for that. Do you agree that
Thank
through
you.
October, rent is $994?
Yes, sir.
All right, the law requires that I adjourn this matter at least 7 days. And you'll
Yeah,
get,
I had talked to Matt when I paid the 2,000 and something, and he said he would work with me on getting the rest paid up.
very good.
And I plan on paying. My daughter is going to help me, and she's planning on paying 150 to 200 every 2 weeks until it's caught up for me.
You want to give her 2 weeks instead, Your Honor?
That's fine. That will take us into November. If we go 2 weeks, Let's take a look at that.
Think
That
that's,
will take us to November 3rd. 140 on November 3rd.
that'll work.
That's fine.
Now, let me tell you. You'll get 10 additional days from that day before the writ of eviction could enter, which would be November 13th. But an additional month's rent will accrue. I don't have a lease. Is there a lease?
There is not.
Yes.
You say there is, Miss Sparks?
Yes, I believe it ends at the end of this month, though.
All right.
Is it with Charlie Dotson or is it with Matt?
With Matt.
Oh, okay then.
All right, we may need to get that squared away, but
Yeah.
they can agree to work with you to get caught up on the rent.
Well, that's
You've made
what
a
I'm
big
hoping
dent.
Matt will
Got
do.
a plan. They've got, well, they would have 56 days from November 3rd to work with you to get caught up on the rent, and another 56 days before they actually serve the writ. So they have more than 100 days they could agree to work with you. So Mr. Rognus has agreed to bump this out 2 weeks. We'll get another month's rent due after November 1st, but we'll deal with that. So do you have any questions?
No, sir.
All right, I'll see you in 2 weeks, November 3rd at 1:40.
Okay, and it'll be the same way as today.
I'd like you to zoom in. I don't like doing it by telephone only. You're also welcome to come to the courthouse, but yes, it'll be the same way as this.
Okay.
All right, I'll see you in 2 weeks.
All right. Thank you.
Thank you. This is non-payment of rent case, lot only. We were here last. We determined the lot rent was 1,559.74 through October. The court was 742. Defendant is gonna try to get caught up in circumstance. Ms. Swinehart, what's your position?
My job, I'm going back and forth between working a couple days a week to drawing unemployment. And I can't offer them more than 200 a week. And they decided that they didn't want that, so I'm not sure. That's all I can't. I have no money.
All right, but
So,
you own the trailer.
yeah,
All right, well, they're buying a pig and a poke here. Does this order give them the authority to remove your trailer? And I said, I'm not even clear. Some courts don't allow this. I don't have a judgment here. I wish I did. Ms. Mattson, what's your position here?
Your Honor, first, the numbers remain the same from the last hearing, so the total balance is at $1,777.18. And Your Honor, it is our position that the law does allow for judgments of tenant-owned homes. First of all, if it were to be a just cause, they would have to continuously pay the rent in order to be able to remain.
I understand. I'm one of the courts that allows it, and I've
Okay.
seen briefs both. I've seen your brief. Some judges, one county in particular, Livingston, doesn't
Yeah.
allow these. You have to file a just cause or none. But what the relief you get is you get the right to remove her trailer from your lot, which is maybe practically impossible. How long's this trailer been there?
Your Honor, I am not sure. I do believe My client is on.
Ms. Weinhardt, how long's the trailer been there?
Over 10 years.
All right. They can agree to work with you to get caught up on this. Boy, I got a ton of people in the waiting room. This day is really kind of just caught up with itself. And I don't have a judgment. So Ms. Mattson, I'm going to ask you to email me a judgment at 3bcivil@stjosephcountymi.gov. It's that notice, that address is on the notice. So we've got $1,559.74 of lot rent, which is due through October, $182.44 in court costs, for a total of $1,742.18. This order would give them the authority to remove your trailer within 10 days. There are problems. One, whether the trailer can be removed, and B, where to move it to. So they can still agree to work with you to work out some sort of a plan to get caught up on this. I drove through the park last Thursday. There are lots of open pads. Maybe a third of the park is, the homes have been removed. And I don't know if they're going to try to re-site some or what they're going to do. But they've got a core of people like you that have been there for years and years, like it there, like to stay there. They're under new management. They've got a different worldview than perhaps the previous managers did. And this is happening all over St. Joe County, all over Michigan, and all over the country. Large companies are buying small, locally owned mobile home parks, and they're turned over to management companies, and they have a different view of things. At least yours is hooked up to city water and sewer. I got some others that have got water and sewer problems. And then this whole issue, no one's ever challenged it. It has been in some, I haven't had a lawsuit that says, hey, you can't do this. You can't file a demand for non-payment of rent in a mobile home lot only. The problem is the other remedy is even worse than this one. They remove you in 10 days, and then they have 90 days to move or sell the mobile home. So one option you may discuss is selling or transferring your mobile home to the park and moving somewhere else. That happens fairly often. But I find that you owe that amount of money, $1,559.74, $182.44 in court costs for a total of $1,742.18. That's only through October. Another month's of lot rent will be due on November 1st. 10 days from today is October 30th. They can remove your trailer. Boy, it's been a while since I had this many people in the waiting room all at the same time, within 10 days. So my suggestion is you stay in contact with the management. Pam, they're locally, Bonnie is the regional manager, discuss what your options are. They can agree to some sort of a repayment agreement. They don't have to ask for a writ of eviction for 56 days. And then they have 56 more days before they serve it. So they have 116 days to try to get caught up. The other option is you could agree to transfer your mobile home to them and apply it to back rent, and then you would move somewhere else. That's an option. But if they get what they ask for, they can move your mobile home. It's going to cost more than the amount of rent to move it. It might cost $10,000 to move this thing off the lot. So this is a thorny issue without a good answer to it. And I see it every month. Ms. Mattson, you have anything to add?
No, Your Honor, would that just be a judgment by hearing? Our office will prepare that and submit it.
Yes, it'll be that amount. The date, 10 days from today is October 30th. The appeal date is October 30th. And it would give the authority to remove the mobile home from the lot.
Thank you, Your Honor. I can place that in the further orders as well.
All right, thank you.
Thank
All
you.
right. Do you have any questions, Ms. Swinehart?
So I have 10 days to move out.
Well, theoretically, you don't have to do anything. You can leave all your stuff in the trailer. They have 10 days. After 10 days, they can move your trailer. And a just cause termination, you would have 10 days to move out and they would have 90 days to move or sell the mobile home. That's more understandable. This is kind of a gray area where they're asking to terminate the tenancy of the trailer. So if you do move out in 10 days, you turn the trailer over to them, that would satisfy this. All right, you're good to go.
Thank you.
Three Rivers Village versus Kimberly Pfeiffer and any other occupants. Last time we were here, Danielle Paliga was here from Payless Law. This time we have Casey Matson. The arrearage was $4,755.02 plus cost for a total of $4,937.46. The defendant had made no provision to move and was not really prepared. Plaintiff did file an amended complaint adding water and sewer and late charges. Total rent $4,755.02 plus the cost. Ms. Matson, what's the status here?
Your Honor, this is actually a rented home. This home is not owned by defendants.
Yes.
And
yeah, this is lot and trailer. And it was hard because the original judgment or the original pleadings only had the lot rent in it of $378 per month. So that was part of what the amended complaint was about. All right, go ahead.
Your Honor, since the amended summons and complaint was filed with the court, there has been an additional late fee that has applied as well. So the total is $4,790.
All right, break it down for me.
Your Honor, since the amended summons was filing, which summons and complaint was filed, which was $4,750.
Oh, well, how much is rent?
Your Honor, monthly rent is, the lot rent is $378.
No, how much is the total rent arrearage right now?
The total rent arrearage is $4,790.02.
That's not accurate. Some of that is water and sewer and late. So how much is rent? How much is water and sewer and how much is late?
Your Honor, the rent charge would be past due and owing from August, September, and October. So that would be the $1,373.64. So the total rent that's due and owing is $4,120.92.
All right, how much is late fees?
Your Honor, there is a $50 and a $35 late fee each month.
You can't charge $85 a month late fee. I don't know what other judges allow, but you can't do a late fee on the lot and on the trailer. We'll allow 40. How many months of late?
Your Honor, there would be 3 months.
$120 in late fee. How much is sewer and water?
Your Honor, the sewer is, it varies based on usage each month. So for August, the sewer was $71. The water was $47.22.
This is very cumbersome. I've got 30 people in the waiting room, and I don't know what other judges do, but I ask these questions every time. It's fair to the tenant to know how much is rent, how much is late fee, how much is sewer and water. When we have to calculate it month by month, it takes a long time to do it. It makes everybody else wait. So
Your Honor,
let's,
if we could pass
let's-
this matter and I can get those numbers.
all right, well,
Okay.
let's just keep plowing away. But next time you come, I'm gonna ask you these straightforward questions. And I'm not, like I said, they do it differently in different places, but these are pretty fundamental questions. So the total amount of sewer and water, August, September is what?
Your Honor, I would need to calculate this out.
All right, I am gonna pass you.
Thank you.
Everybody just wait a minute while we work on Three Rivers Village. We'll skip ahead to Pine Valley Place. What's the status here, Mr. Weiner?
I have, unless Chris, have you heard from these tenants this
No, I-
last week?
No, I have not.
Okay, so Your Honor, at this point, when we were here last week, we had filed a complaint. We asked for additional rent and fees. The total of the amount that had been due in rent, as well as the additional rent and fees for September and October, were $5,125. And then there were costs of attorney fees of $75, service fees of $51.20, and a filing fee of $130. If I add $256.20 to the $5,125 that were due, these tenants owed a total of $5,381.20.
Yes, that's what we came up with last week. Mr. Applegate, Ms. Gardner, what's your position?
We've reached out to several places, including Neighborhoods Inc., and we've been working with them a little bit. We're waiting on the I don't remember the abbreviation for it, but we're waiting on some of the paperwork to come back currently. But I've been talking to them and trying to get as much help as I can that way, as well as reaching out through some VA help.
All right, you also are eligible for VA. Are you eligible for VA benefits?
I am receiving paperwork in the mail today to be notified if I am.
Oh, that could be very helpful. All right, I'm gonna issue this judgment. And I wish I had a judgment. The local attorneys give me a judgment and the out-of-town attorneys don't.
I'm gonna
I think
send
maybe they
that,
do
Your Honor,
differently.
I have a judgment, so I'll email that to you.
If you would, thank you. I find that through October, rent is $5,125. Court costs are $256. The total amount due is $5,381.20. That's due by October 30th, which would still be in the same rental period. Now, you have to pay the entire amount. Partial payment will not prevent the writ of eviction. They can agree to work with you. Ms. Corpening knows this well. During COVID, when we were getting all kinds of emergency financial assistance, sometimes they had to wait for their money, but eventually they got it. At one point, they had the right to decline to participate in the program. Now, I think they're compelled to. If there is a funding source, they're required to accept it, and certainly some money is better than none. Also, to emphasize, on October 1st, another month's rent is going to be due. So when you get this judgment, I want you to share it with your Neighborhood Inc. and the VA and others, and they'll say the actual numbers. I used to put in the next month's rent. I would put in November's rent in this, so the funding sources would see that. Some courts did that, and some courts didn't. That was appealed by legal aid, and Judge Stutzman ruled I couldn't do that anymore. So November's rent is not included, but be sure and let them know that another month's rent is going to be due on November 1st. All right, let me repeat. You owe $5,381.20 by October 30th, or you're subject to being evicted. Partial payment will not prevent the writ of eviction. You have to pay the entire amount. Do you have any questions?
Sir.
I do.
Yes, go ahead.
We still haven't gotten a key for the mailbox.
Yeah, she was working on that. Ms. Corpening, any luck with that?
I reached out to the post office to have them check and see if the key was still up there, but I've not heard back from anyone. We have not had our regular post worker. She's on vacation, so I'm not sure if the new one has any idea how to do that. But I will reach out again.
All right, thank you.
Mm-hmm.
Well, you need this piece of mail, and now you can't get it in your mailbox. I would recommend you come up here to the courthouse and get a copy of this order so you can share it with your funding people, okay?
Yes, sir.
Come right to the district court and ask for landlord tenant, and they'll give you a copy of it.
Okay.
All right, thank you. Last month, we determined that through October, what was $3,845, $256.20 in cost for a total of $4,101.20. You've been working with Neighborhoods Inc. and they thought they were going to give you some assistance. So what's our status, Mr. Weiner?
The amount that you recited is accurate. Chris, have you heard anything from Ms. Blizzard since last week?
No, I have not.
So there's no change of status from our end, Your Honor.
All right, Miss Blizzard, I'm going to do the same thing as I did in the last case. I don't have a judgment in front of me, so let me quote it from memory here. Rent through October is $3,845. You owe $256.20 in court costs for a total of $4,101.20. That will bring your rent current through October. November 1st, another month's rent is due. So be sure and share that with Neighborhood Inc. or whatever your funding agency is. The only thing that will cure this is paying the entire amount. Partial payment will not prevent the writ of eviction. So it's important you stay in contact with your manager, Ms. Corpening, and your funding agent. Worst case scenario, unless you pay the entire amount by October 30th, you could be subject to being evicted, where they put your stuff out on the street. And that's not a very good Halloween present or Day of the Dead. So hopefully you can get some assistance and you can pay the balance, and then your rent will be due on November 1st. Ms. Blizzard, do you have any questions?
Well, I was going to ask if it's possible to, I don't know if there's any type of extension of some sort that I would be able to get, because.
Well, let's talk about that. They don't have to evict you on October 30th. They have 56 days from today to ask for the writ of eviction. So there'll be time to, now let's say they're going to deny you, or they're going to give you $1,000 and you owe $3,000. Then you should consider your options of moving. But I'm not going to sign a writ of eviction until I know that there's been an effort to pay this. So I don't know that they're going to give you money. They were out of money at the end of September. A new fiscal year started October 1st. My sources tell me they have funding and they're helping people right now. So I'm hopeful you'll get some money, but they don't always pay the entire amount. So stay in contact with your manager and stay in contact with the funding agent. As soon as you get this judgment, do you have mail problems too?
Not that I'm aware of.
All right, you get your mail?
Yeah.
All right, then you'll get this in the mail next, except the mail's pretty slow. If you want a copy of it sooner, come to the court or call the court and ask them to email a copy to you.
Okay. The last time that I talked to Neighborhoods Inc., they said that they have not been able to contact Memory Lane's management and that they have paperwork that they're waiting on.
Well, she's there all day, every day. So have you heard
No.
from Neighborhoods Inc.?
Are you asking me, Your Honor?
All right. Well, they need to try to get on the same page. She knows how to do this. She's done it many times. And it's in their interest to try to get this paid.
I've also contacted Community Action and they have agreed that they can also help me. And I just submitted all of the verifications and everything that they needed 2 days ago. So I'm hoping if Neighborhoods Inc. doesn't end up contacting Chris, then maybe
Well,
Community Action will.
all right, very good. Stay in contact with everybody and share this judgment. Mr. Weiner's gonna send me one and I'm gonna sign it. I'm gonna get it to you.
Okay.
Got it.
All right. Thank you. All right. You can take a recess. You're good to go. Mr. Weiner, I think that finishes all of yours. We were here on October 10th. All of the same parties were here. Danielle Palia was here, but Bonnie was here. Lois, the local manager, Pam was here. And this was lot and trade. No, this is lot only. Cousin owned the trailer. So this is a little bumpy. Defendant made a payment plan proposal. Ms. Mattson, what's the status here today?
Your Honor, at this time, we are requesting entry of a judgment. There is a fresh start agreement that Ms. Ellsworth signed with my client to pay the past due balance.
Just a minute. Ms. Stewart, I'm gonna put you in the waiting room. You're driving me crazy. I'm watching things wiggle and squiggle and I'm gonna pass out from vertigo, so I'll put you in the waiting room. All right, I'm sorry. Go ahead, Ms. Mattson.
Your Honor, there was an agreement that Ms. Ellsworth did signed with my client for the past due balance prior to the new ownership, which was $100 a month, which she did sign and my client did also sign, and they have been charging her accordingly. However, she has not paid. So therefore, we are requesting entry of a judgment at this time. The past due rent is $1,464. Past due utilities is $420.22. And there are late fees of $255 for a total of,
How were the late fees calculated?
Your Honor, there is one $50 late fee at the beginning of the month. And then one $35 late fee after the 18th.
Yeah, you can't do that. I'll do a $40 late.
For the record, we would just object to that as there was a lease signed reflecting those late fees.
Yes, people have a lease where they charge $10 a day late fees or $350 late fee. Just because it's in the lease doesn't mean it's allowable under the current status of the law. In fact, the whole idea of late fees is still somewhat unclear, but I'll allow that. So let's do the numbers. 1464 plus 420.22 plus 40 equals 1,924.22. Now, did she make some payments? Because it's actually lower than it was before.
Your Honor, I do not see that a payment was made since the
Well, when we were
last.
here last time, it was 2,104.22. Now it's 1,464.
Your Honor, that is the rent, not including the utilities. I believe
Okay, I
the
guess I reduced some from the late fee, I think is where that difference is. All right, Miss Ellsworth, what's your position?
Your Honor, I actually have $2,000 that I can actually pay towards it.
Very good. That would solve it through October. Of course, November 1st,
Correct.
another month's rent is due. All right. Miss Matson, if you'd send me a judgment in that amount, we had kind of a rough go of the day. Maybe next time it'll be easier. They threw you in the pool and said swim, and here you are with me. So
Yes,
we're
Your
doing the
Honor.
best we can.
I will.
Rent
be sure.
1,464, utilities 420.22, and a $40 late fee, 1,924.22 due to October 30th.
Your
Partial
Honor,
payment. Yes,
Your Honor, would that be $40 late fee per month?
yes. How many months was there?
There's 3 months, Your Honor. Yeah, so it would be 120. So the total for that, all three, is $1,004.22 plus the court cost of $182.44.
You broke up a little bit. Let me try this again. 1,464 plus 420.22 plus 120 in late fees is $2,004.22.
Yes, Your Honor. And then the court cost of $182.44.
Yes. Equals 2,186.66. All right. You say you've got $2,000 to apply to that. That should just about pay it.
Yes,
Ms.
Your Honor.
Ellsworth, so you plan to pay it?
Yes, Your Honor.
Very good. Stay in contact with your manager. Let her know what your intentions are. If you pay it, you don't have to worry about any eviction on or after October
Yes.
30th. November 1st, another month's rent is due.
Yes, and I know I do gotta get a hold of Pam for a current lease as well, so,
Yes, also need current lease.
yes.
Very good. All right, Miss Pfeiffer has rejoined us. Miss Pfeiffer, are you there? She was momentarily. Each one of these took a half an hour when they block out 5 minutes. And we're just getting farther behind. Miss Pfeiffer, would you join us, please?
Your Honor, am I excused?
No, one of the clients came late, so we're waiting for you. Miss Ellsworth, you're good to go.
Thank you.
Miss Pfeiffer? Kimberly Pfeiffer, could you join us, please? All right, you're all good to go.
Thank you,
All
Your
right,
Honor.
thanks. All right, the complaint alleges that on or about June 19th, you stole some mascara that belonged to Daily Brokema, the value of which was worth less than $200. That sounds like quite a heinous crime. I don't know what mascara goes for these days.
Like $10.
$30. Apparently it's on video. Apparently she sells mascara at her provisioning store. Anyway, the allegation is that on June 19th that you stole some mascara from the Daily Dope store. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. You posted a bond in that matter, set by Judge Pattison of $1,000 PR on July 28th. Then you promptly failed to appear for further proceedings. So we had to drop everything to address this.
I was out of state, Your Honor. My mother had passed away, and then my father had passed away, and then I have been currently diagnosed with HIV, and I also have other health problems.
All right. Well, how long have you been in jail?
I've been in jail since last Thursday, sir.
I was gone Friday, and so was Judge Pattison. So you had to wait all the way. So you had one day at the front end, Thursday, Friday, Saturday, Sunday, Monday. You got 5 days of jail credit. I represent to you, sir, that if you plead guilty to this charge, I will give you 5 days in jail, restitution, and the minimum allowable fine, and let you out of jail. However, you have a right to continue your plea of not guilty and have me set this for further proceedings. What would you like to do?
So if I plead guilty today, does that mean I get out today?
Yeah, if there's no other hold on you.
Yes, I would like to do that, yes.
Your Honor,
Other than what I just,
I apologize, just to
Great.
confirm, this isn't a case where he has had counsel appointed yet, correct?
I don't believe so, no.
Okay.
It was, they set it for an attorney, a prosecutor pre-trial didn't show up.
Okay, I just wanted to confirm I didn't need to notify other counsel.
All right, Mr. Stevens, other than what I just told you, did anybody promise you anything to get you to plead to this?
No, sir, I did do the crime, and I do know the lady myself, and I
All right,
tried to.
will anybody threaten you to get you to plead to it?
No, Your Honor.
Do you understand that if you do plead to this charge, we're giving up your right to have a trial in front of a judge or a jury? There will be no trial. Do you understand that?
Yes, Your Honor.
If you had a trial, you'd have the right to be represented by an attorney. Ms. Harden is here to look after your rights, but she's not actually representing you. You could ask for full appointment, and I would do that. You could also waive it and simply enter a plea of guilty based on what we discussed here. You had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes, Your Honor.
What prompted you to steal some mascara from a weed store?
To be honest with you, I was being stupid, Your Honor.
Well, that's a pretty honest answer. Do you even use mascara?
The girl I was with does, yes, sir. I'm no longer with her, so I'm over that part.
All right. 5 days jail credit, 5 days. You know, $125 in fines and $30 restitution to Daily Rokema. She owns Daily Lash and Spa as well as Daily Dope, maybe some other enterprises. Total is $155.
Yes, sir.
I'm gonna give it, I'm gonna make that due by November 30th. I'm not gonna leave you in jail because I want to get the restitution. I've got Venture Boulevard, Unit 4 here in Centerville. Are you still there?
No, sir, I'm currently staying at, Bent Waters Apartments in Three Rivers.
Do you have a ride home?
Yes, sir, I can call somebody as soon as I leave here, yes, sir.
All right, if you don't, come here to the courthouse. I'll give you a bus pass and we'll get you back to Three Rivers. Stay
Yes,
out
sir.
of the daily dope. You're barred from,
Yes, sir.
for 1 year.
Yes,
You
sir.
owe $155, $30 to the merchant and $125 cost to the state.
Yes, sir.
All right, what's your unit number at Bentwaters?
It's Unit 14,
What's the street address?
Heather Lane,
What?
Heather Lane. Heather Lane, Unit 14,
Do you know the number,
cell phone number or?
the number of
No,
the
the
street?
the house number.
I can't remember. I've just started staying here with some friends. They noticed
right.
that I was staying behind Goodwill and a tent, so they just invited me to stay with them to get out of the cold. But I can make sure the courts gets that ASAP, so that way I don't get in any more trouble.
All right. Well, you haven't got money to spend on weed or mascara. You need to maybe get somewhere warmer. All right, you're good to go.
All right, thank you, Hunter.
You should get booked out. If nothing else is holding you, and I
No,
didn't
sir.
see that it was, you should get booked out shortly.
All right, thank you, Hunter.